or we can stop the record.
There's 4 attendees. I guess they're waiting to come in. Julia Hood, Bria Brown, Venitra Gavin, Erica Black. Are they on?
It says that we're live.
Okay, so good morning, everyone. We have a few people who have already joined us, and to respect everyone's time, we're going to get started. I'm going to apologize for now for not being on video. My staff understands what happened. I had a family care responsibility, and I had to spend the night in the hospital with my mother-in-law, and so I'm not in a place to be able to, or in an attire to be on video. So here's how this is going to work. The first thing I want to do is just thank you all for being here, and this is typically it's a nice little Saturday morning, spring morning. But this one is just got a lot of rain out there. So what I want to do is really just kind of jump over to what we're doing. Many of you know me already. I'm also trying to figure out how to move my mouse to get it to work. All right. So most of you already know who I am. You already have my background, and what was going on. So if to do a webinar, this is actually the best day to be able to do that. So with this kind of rain and grayness over here. So before we get started, I just want to kind of run through a couple of housekeeping matters. The first, my intent is not to make this presentation long. I'm going to provide a general overview of what your roles are, or what your fiduciary roles are, and the duties and responsibilities. This is not expected to be an end all or and be all. Absolutely not in a short period of time. There will be some time for some Q&A at the end. So as your questions come up, please post them in the chat, and my staff or I will be able to review them at the end. Please note that I will not be able to answer any personal or client-specific questions due to confidentiality reasons, and you kind of probably would appreciate that. But if you stay to the end of the presentation, you'll see that those questions can be addressed, and we have a way of being able to do that. The next thing is this presentation is going to be recorded and will be made available to you for review. However, the slides will not be made available to the public. So without further ado, let us begin. All right. First thing, what's a fiduciary? Fiduciary in your estate plan typically finds three roles. It's the attorney in fact, and that's the individual who kind of just manages the money for the property for someone else. And when you have a person that's named fiduciary and they accept that role, that fiduciary by law must manage the person's money and property for your benefit, not theirs. Okay. The fiduciary must manage the person's property for that person's property, not their own. There are both criminal and civil penalties if they violate that role and that responsibility. So it's not just something we do happenstance. Okay. And then, by the way, and it's not just property and money. It's also if you have the person that's responsible for making your healthcare decisions, they also have to be making the healthcare decisions in your best interest. And so if you look at your healthcare documents, particularly your living will and your healthcare power of attorney, it requires that the person making the decision is not, not, I shouldn't say that the witnesses to that document are not your beneficiaries and are not responsible for your care. So they want to make sure that the person who you're assigning is an independent person for that purpose. All right. Okay. So what's the first one? Power of attorney. We refer to that as the attorney in fact. All right. You have those three potential roles. Like I said, is the attorney in fact, personal representative, and the trustee or the successor trustee. Under power of attorney, you are commonly known as under the will, the personal representative is commonly known as an executor. You nominate that person in your last will and testament or your pour-over will. Remember, your pour-over will is only if you have a trust. We'll discuss the difference a little bit later. And probate is still required for any will, whether it's a pour-over will or it's a last will and testament. And it does require that the court gets involved in that process. Hopefully, if you've done a trust and it's been fully funded, we'll give you a link to a blog for that in the chat. And we'll also follow up with you to make sure it's fully funded. And the last one, to be a trustee or successor trustee, requires the creation of a trust. Okay, so now I'm going to talk about the power of attorney. The attorney, in fact, is first is it means very little to people, and they often get confused about that. It says, well, if you're my attorney, then who's my attorney in fact? It's just a legal phrase that we use because you have stated it in your document that based on this circumstance and this fact pattern or these facts, this person has the legal representation to make decisions for you. But even for people who are very educated on the subject, the power of attorney is kind of confusing for them, and it's easy to forget who serves in what role and why. So to start, it helps to understand that being asked to be an agent under a power of attorney, that person's appointed and becomes a representative of the principal's finances, as well as some legal decisions. So it's not just finances, but it's also legal decisions. And in effect, when you assign someone to be your power of attorney, they're gaining permission to step in your shoes, the shoes of the principal, and to act on your behalf. Right? So that's their primary role. For those appointed to a limited power of attorney, though, the agent's power is very specific. If you've ever bought a house and you gave the title company a limited power of attorney, and that limited power of attorney is for the purpose of being able to correct scrivener's errors. So they don't have to call you all the way back in to just correct a typo or something that was there. So you give them a very limited and specific power of attorney. If you want someone to handle a bank transaction for you, you can create a limited power of attorney for them to handle that one particular transaction because you're not going to be available or what have you. Right? So it allows people to be able to accomplish some things. If you're out of town and you know you're going to be out of town, you know you're going to be hospitalized. I had surgery. Some of you know I had surgery 2 years in a row. And so if I didn't have my wife and I knew I was going to be incapacitated for a period of time, then I would just give that power of attorney for that limited period of time that I knew I was going to be down and out and not able to function on my own. All right. Okay. All right. So with a financial power of attorney, it's not valid in certain situations. Knowing when your power of attorney will not be recognized is an often overlooked estate planning aspect of estate planning. Financial power of attorneys can be very broad, but they are not recognized in all situations. For example, you may, if you want to authorize an agent to work with the IRS or the Social Security Administration or even the Veterans Affairs, and some financial institutions, you may have to complete additional documentation. The IRS has its own means of designating an agent. Before an agent can represent you in front of the IRS, they have to complete this form. It's called Form 2848, Power of Attorney and Declaration and Representative. Sorry. That form authorizes an agent, typically referred to as an enrolled agent, an accountant, or even an attorney, to represent you in audits and negotiations. But the form is also required if you just want an agent to handle basic tax matters, such as filing your tax forms or paying your taxes. All right. According to the instructions on that form, the IRS might accept a power of attorney that meets all the requirements for being a substitute and is submitted to the IRS along with the Form 2848. Although your signature is not required, your agent must sign that form. So that 2848, you don't necessarily have to sign it, but the agent must sign that form on your behalf. And it requires you to specify the tax matters, what specific tax matters they have the power of attorney for, and the years of which you are authorizing the agent to act. So based on what I just said before, this would actually be a limited power of attorney because they need you to say specifically what tax matters it's for and for what duration or what period of years you're looking for. You cannot leave it open-ended. Working with the Social Security Administration, they definitely do not recognize financial power of attorneys. To designate someone to manage your Social Security benefits, including SSI payments, you must appoint a representative payee, and you can appoint that person in advance. If you do not appoint someone and the need for one arises, Social Security will appoint one for you. A potential representative payee must complete that form. It's called the SSA 11, and usually it's done in-person application at their local Social Security office. Representative payees are expected to fulfill a range of required duties and be actively involved in the beneficiary's life. They may occasionally be asked to submit a report to the Social Security Administration, what's called an accounting, so that they can kind of account for how they've used the beneficiary's benefits. All right, so now when you're working with financial institutions, it's very important to recognize, and I believe we have someone on here. I see Julia. I'm not going to call her last name, but Julia had this situation when we first began. We did our financial power of attorney. She went to the bank, and her bank did not recognize it, and so we had to do some other things in there to be able to get it done. But in most cases, in some cases, it may be a simple exercise of just going to the bank and asking, what form do you want? What form do you need? And if it needs to be notarized, they can either do it right there. And if not, we can always modify documents accordingly. And the banks do that because they're trying to exercise extreme caution to protect themselves from authorizing an illegal transaction. Now, in some states, including Florida, financial institutions may be legally required to accept and reject a power of attorney within a certain time frame and could face penalties for unreasonable denials. So for the sake of expediency, check with the financial institution and find out whether they have their own power of attorney forms. If they do, bring the form to our office to be reviewed and executed along with your power of attorney. Well, you've had that already. And so if we need to ensure anything else or any language there from your existing documents, we'll modify them to make sure there's no conflict. All right, so we're talking about your your personal representative. Right. Personal representative, their duties and responsibilities is very, very similar. Very similar to the successor trustee. Both must collect and manage assets, pay debts, and then ultimately distribute the assets to the beneficiaries. It is very important to note, however, that the personal representative is only nominated by someone to serve in this role, right? So when you create that will and you're nominating a person, you're naming them nominated, it is only a recommendation and a nomination. The court must confirm that, which is why your will has to go through probate, right? And remember, it's typically you'll hear the term administrator, you'll hear the term executor. If you watch TV, you always hear the executor. Well, Maryland, DC, and Virginia, they use the term personal representative, right? So around here, that's why we use that term. But if you hear personal representative, then it also means, in state planning terms, I'm also talking about executor. That's the person who's named in the will and appointed by the court, and ultimately is responsible for probating the will and settling the estate. Again, if you have a trust, all right, it's the pour of a will, and all that's settled. Settling that estate is just taking the assets and putting them into the trust. If you have just the last will and testament, then whatever that says, however that distributions occur, is what happens there. And depending on what jurisdiction you're in, the executor or personal representative may work under court supervision or may use a so-called independent administration for an unsupervised probate. We always, in all of our documents, because you're appointing someone you trust, have that person do unsupervised probate, which means that the court doesn't have to follow every single step of the transactions. It usually makes that quicker and makes it cheaper for the clients. Okay. So typically, the petition probate must be filed with the court for a personal representative to be appointed. If the person agrees to be the executor and no one objects, the court will issue letters of administration, or their they call they're legally letters of testamentary, but they're basically we refer to them as the letters of appointment. This letter authorizes the personal representative to gather the estate's assets, to sell assets, pay creditors, and to open the estate bank account. The first duty of the representative is to protect and preserve the estate's assets. The first duty of the personal representative is to protect and preserve the estate's assets. And that sometimes can create some tension, because if you have siblings or other people involved who may not be related to you, and you're saying, no, you can't take that. No, you can't have that. You can't. Well, it was my dad, but I want the first responsibility, and it may include having to change the locks once appointed. And so that can create some level of attention. So it's very important that people understand that all they're doing, and all you have to say is that all I'm doing is carrying out what the law requires me to do. I have to preserve and protect these assets. Eventually, once we go through the process, you will get them, right? The representative should attempt to put together an inventory of all those assets and the values at their date of death. And sometimes that might be difficult, particularly if the estate's being opened up long after the person passed away. But often it's not as difficult, and we always recommend opening an estate as soon as possible. Then after that is to check for whatever powers you may have been granted over the property that's referred to in the will. So does it say that you can sell it? Does it say that it has to be rented out? Does it say it needs to be retained? Does it say to pay off any debts that are associated with it? To say, does it transfer it with the debts? So the will lay out what the obligations and authority you actually have with those documents, with the assets. And I would always recommend, even if you don't hire the attorney going all the way forward to help you through the entire probate process, I always recommend to have an initial consultation with an attorney to talk about what powers and what does the will actually say. If you feel confident and bold enough to do it yourself, not recommended, then by all means. But I always recommend having that, at least that initial consultation, right? Then finally, the executor is responsible for distributing the assets to whoever the beneficiaries are, the heirs, according to the terms of the will. If there's no will, well, in your case, there are wills, but just in case if there's not, your executor will distribute the assets in accordance with state law or District of Columbia law. And those of you know how I feel about that, but I will continue going. I will just skip that. No politics today. Distribution of the estate assets in either case happens only after debts, taxes, and administration expenses have been paid. All right. So that kind of gives you the overview of terms of the initial responsibilities of the personal representative. Now, what do we mean when we say about paying those debts and taxes? The first step is to consult, like I said, the documents to clearly define what your duties and powers are. There may be claims put against the estate. And that's why there's what's called this publication period or this creditor notice period. It puts it out there to the world to say, hey, this person's passed away. They have an estate. If you have a claim, say now or forever hold your peace. Right? So they may put a claim out there, and it may be required to be paid from the estate or from the trust. If one exists, and the representative may have different responsibilities and latitudes with regard to making those payments, there's statutory orders in which creditor claims can be paid or must be paid. The local court is always going to get paid first. Well, I shouldn't say that. Funeral expenses always gets paid first. So if there's someone paid for someone's funeral, they will always get reimbursed prior to anyone else, including the court. So funeral expenses always get reimbursed, and then after that, it's the local court. It'll be the personal representative or the attorney who's representing the matter. Generally, then the IRS will come in place, and Medicaid, Medicare, if they look for reimbursement, and then you start going down to the secured assets or the unsecured assets. All right. So there's a statutory order if there's only limited funds. If there's enough funds to pay everything, then the order really doesn't matter. All right. All right. So death taxes may also need to be paid. Now, there's no such thing. Well, I shouldn't say that. we review the phrase as death taxes, but it's only if your estate, it's only if the estate is over a certain amount. So you hear the phrase death tax. That's all right now. It's only if your estate as an individual is over $12.5 million, right? And as a couple is over $25 million. As I tell people, a lot of my clients, most of my clients, almost all of my clients, I say, the good news is you don't have to worry about this death tax or this estate tax. The bad news is you don't have to worry about this estate tax because you don't have the $25 million or the $12.5 million. All right. But that must be resolved within 9 months of death. One other thing I want to just remembered regarding, or I was just reminded about, regarding the funeral expenses. If you've done your plan with me, this is not an issue. But if you don't have a will and you haven't done a will, then there are limitations in terms of how much funeral expenses can be reimbursed. So, for example, in Maryland, it's a maximum of $15,000. So if there's no will, and then you're seeking to get reimbursed from the estate, you're putting a claim, you can only get up to $15,000. In DC, it's $5,000. Now, I have no idea why the numbers are so low. If you've had to bury anyone recently or anything been involved in that, you understand that both $5,000 and $15,000 are very, very, very low threshold numbers. So it's, again, another one of those small reasons to make sure you have your estate plan, because we put in there that number is waived. And so the personal representative that you appoint can be reimbursed whatever the full amount is for the for burial, funeral, burial, cremation, and memorial costs. Okay. All right. So without going into too much detail regarding all the income taxes and everything like that, I'll just say that within 9 months, that estate tax return has to be done, and it has to be paid. Right. Typically, an estate can pay professional fees such as attorneys and accountants to help them do all of that. But the will should be consulted first to confirm whether or not those individuals can be paid out of the estate. And also, some of the fees and expenses may not be payable until the estate is subject to probate, or until distributions are ready to be made to beneficiaries. So please don't forget. Also, if you have any questions, please put them in the chat, and we will get to them as we go along. All right. Okay, so now we talk about distributions. Beneficiaries may be entitled to ongoing payments of income or principal for a period beginning with the death of the decedent, or may be entitled to lump sum payments. So the representative may be allowed. Remember, when I say representative, executor, personal representative, may be allowed to distribute the property in kind, or sell the properties and distribute the cash. We have situations where you may have a home and you have 3 siblings, and one of the siblings wants the house. Well, okay, that's fine. They can get the house, but then they're going to have to refinance it or find cash out of their own pocket and give the 2/3 value of that house to their other 2 siblings. So if the house is worth, I'm going to do simple math here, $300,000, each person's entitled to $100,000. These are the 3 siblings. Well, the person who acquires the house, fine, they get it, but they now have to give $200,000 or $100,000 to each of their other 2 siblings. So they can either refi the house if the house has already been paid off. They can look to other monies in the estate. So if there's also bank accounts or life insurance policy or something on that line, they can take it out of that, but they have to give it to the other beneficiaries. Now, those beneficiaries can waive, and they can renounce it and say, no, they can have the entire house. I don't want the $100,000. I have yet to find a client who says that, but that is possible. So they can waive that and renounce that. If the person wants to buy the house, but they cannot afford the other $200,000, then the personal representative will be obligated to sell the house and make sure the shares are distributed accordingly. All right. And again, the provisions regarding all of the distributions to the beneficiaries are typically laid out in the will and trust documents. And the final distribution, at the final distribution of any remaining assets, it's advisable for the representative, the executor, to obtain receipts from each beneficiary. You need to make sure a document. And that's something I want to say, I meant to say in the beginning. As any fiduciary, Document, 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 document. I don't know how many times I said that, but whatever time I said, I didn't say it enough. Document what you do. Document every penny that's spent, where it's spent from, where and who it went to, and what it was for. Those of you who are old enough may recognize the term, the salt and pepper book. Back in grade school, we used to call them little black and white hardcover books, where, and the reason why we had those, because the teacher could always tell if you tore out a page, all right? So it was bound in there other than, than loose leaf books. So you get one of those books and you just document and use that as your ledger for all transactions in the event something comes up later on. So it's very, very important. Document, 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 and get receipts for anything that you do. Okay. Now we're going to talk about the revocable living trust and the parties involved there. Revocable living trust, RLT, is created during the client's lifetime and can be changed until anytime until the client becomes incapacitated or passes away. This planning tool allows the client to act as a grantor, to name himself or herself or themselves as the current trustees, the person currently in charge of managing and investing and handing out the money in the property, and to designate a co-trustee or successor trustee if the client is unable, for whatever reason, to act as a trustee. That unable, and I want to say for whatever reason, it could be because they're traveling, because they just don't want to deal with it right now. They're planning, they're starting a new business. Like, okay, here, you handle all the personal stuff for me, all my personal assets, and I'll focus over here. So whatever reason that the trustee grants them that authority, allows them to do that. The trust also allows the client to continue enjoying the money and property as a current beneficiary during their lifetime and to designate what will happen to the money and property upon their death. And that way it protects it for their chosen beneficiary. So it's very important that that trust is not just for the future, it's also for the present. They are the present beneficiaries. So trustees, people who create their trust, they are three people in one. They are the trust maker or grantor, they are the beneficiary, they are the trustee managing the trust, and they are the beneficiary of the trust. Okay? All right. While alive and well, those clients hold all three roles. Right? And the successor trustee can step in when and if the trustee becomes incapacitated or passes away. All right? And if they're incapacitated, that trustee is still the grantor and beneficiary. Go back to what I said about fiduciary. They have to do it for their benefit. All right. So for successor trustees, we're going to discuss a little bit their when their roles go into effect, their duties, responsibilities, powers, how they can be compensated, potential liability, and the distribution of trust assets and self-dealing. Okay, when is it effective? Your loved one or your loved one's spouse, if your loved one is married, is more than likely to name an initial trustee of the revocable living trust while your loved one is healthy and living. So I'm talking right now to the people who take over this role. As the trustee, your loved one is in charge of managing, investing, and handing out the trust money and property to the appropriate people, which if it's you who is naming them as the successor trustee, then if you're incapacitated, then that successor trustee is responsible for your care, right, and making sure you get everyone. All right. There are few situations in which as a successor trustee, you'll need to step in. Prior to your loved ones passing away, there may be a time when they are no longer mentally capable of making decisions or handling their day-to-day tasks associated with being the trustee. This is sometimes referred to as incapacity, or another phrase is incompetent, is not competent, but we tend to use that in the estate planning term as incapacitated. When incapacity occurs, you will be able to step in and continue the management, investment, and control over the trustees, over the trust accounts and property for their benefit during their lifetime and without any court involvement. And often their documents dictate how that incapacity is determined. Typically, if there's a married couple, it'll be the spouse and a doctor. If there's no spouse, then it's 2 independent doctors. You also have the option of appointing a panel of people that you choose, that you have there. So there's really 3 ways of doing it, but the typical one is either 2 independent doctors or the the spouse and the doctor. Right. When your loved one passes away, your loved one obviously can no longer manage a trust for themselves. They're no longer act as trustee. Therefore, you automatically, unless you reject it, you automatically step in to manage, invest, and to use the trust money and the property the way that they laid out in the trust. Okay. And it's important, again, in fiduciary, the way it's laid out in the trust. You've agreed to do that. You don't have to accept the appointment. Right? If for whatever reason you don't have to accept the appointment, you can withdraw. You can say nope, and so the trust will go to the next person if another person is named. Depending on what your loved one's circumstances are, there may be a time when your loved one is no longer able to serve as trustee or wishes to serve as trustee. They may simply choose to resign, allowing you to step in and pick up where your loved one left off, or your loved one could allow you to start early and act alongside them as co-trustee, so you kind of know what all the assets are, what they're thinking, what they're doing, and so that would give you the benefit of knowing what they're doing, be able to start very quickly should and if your time comes when you need to take over the trust. All right. Although you will have control over the trust accounts and property, you will also have duties and responsibilities that you must fulfill. Generally, you have legal duty to administer the trust solely in the interest of the beneficiaries, and to deal with them impartially and without bias. You cannot use any of the trust accounts or property for your own benefit or for any purpose not expressly listed in the trust. It's very, very important. Again, it goes back to that fiduciary role. You also cannot enter any transactions that would create a conflict of interest between you and the trust or a trust beneficiary. Right? So conflict of interest is very important. The trustee should be informed about the sources of your authority. The first source of authority is, of course, the trust instrument itself. To the extent that the instrument does not address a particular issue, the trust code of the relevant jurisdiction that the trust is being administered in will apply. If both the trust instrument and the jurisdiction statutes are silent, then what's referred to as common law or case law will kick in. And so if there's something that falls in the gray area, I like to say common sense will generally prevail. Mm-hmm. So what we have here, we're talking about the duty to administer the trust. Trustee has no duty to act until they have accepted the trusteeship, right? Once you've accepted that trusteeship, then you have the duty to administer in good faith according to the terms and purposes and the interests of the beneficiaries. And of course, in accordance with the trust code and the common sense that we talked about. So you can really only, how do I say this? The duty to administer is an obligation. It's an affirmative duty. It's something that you must do. So you can breach it not only by improperly exercising the duties, but also by failing to act. So if you fail to do something that you were supposed to do, you can also be in breach of your duty. So it's an affirmative responsibility that you have. A duty for loyalty requires the trustee to administer solely in the interest of the beneficiaries. All right. The duty of loyalty is a fundamental obligation of the trustee, and it precludes, this we talked about earlier, the trustee placing any of their own interests above the beneficiaries. You must be impartial. It's obviously kind of related to duty of loyalty. If there's a situation where the trust has 2 or more beneficiaries, the trustee has a duty of impartiality that applies to all aspects of the trust administration, but particularly with regard to investing, managing, allocating and distributing assets of the trust. Must balance the interests of the current and remainder beneficiaries, right? Accordingly, the trustee must be sensitive in the allocation of how much money and how much money is going out, or I should say, how much of the assets are going out and how much assets are coming in, and should reallocate any income and principal to the principal accounts as necessary and as the law requires. Okay. Prudent administration. This kind of goes back to the duty of administration. Although, and there's no real definition of this, is where that common sense kicks in. If you look through the statute of Maryland, DC, you won't see this anywhere. However, if you fail to do something, believe me, they will know when it happens. So this is where common sense really, really kicks in. You must operate the trust as a prudent person would, considering the purposes of the trust, the terms of the trust, any of the requirements for distributions, and the characteristics of the trust beneficiaries, as well as the current economic climate. Let me go back to that characteristics of trust beneficiaries. The trust says that you're supposed to distribute the money to all the 3 children, but you find out that one of the 3 children is a drug addict, has a criminal record for embezzlement, or is under investigation for something bad or whatever, and you fail, and you just follow and say, here's $100,000. You just go ahead and give them money. Well, someone can say that wasn't prudent administration, because the question they're going to ask you is, would the person who owned the trust and created the trust, would they have done that? Okay, would they have given that money there? So it's kind of a gray area, but that's where common sense kicks in. So you will have then, at that point, what we do is we kind of go back to the court and say, listen, I know this is what the trust says, but these are the circumstances. Can I withhold making that distribution? All right, so you really have to kind of look at the circumstances that are going on. All right, then you have to exercise reasonable care, skill, and caution in being the prudent administrator. It's just something that you just have to do. My grandmother many, many years ago told me that, you will grow up to learn that common sense is not all that common. And she is right. As I've gotten older, I've discovered that. But really, as you take on this position, along with all the language and the law, common sense will really help guide you along the way. We talked about this already. Duty of record keeping and identification of trust property. Keep records, right? Protect the assets, secure them so that you know what is there. Control and protect the property. Again, we talked about that as well. This is a duty that may be altered by the terms of the trust, however. So, for example, if the terms of the trust allows the beneficiary to occupy the settler's house rent-free, this would prevent the trustee from taking physical control of the house, right? So, if you can stay there, ordinarily, if you allow someone to stay there, or if the trust says that the beneficiary can stay there, then you as a trustee can't take control of the house, because the document says the beneficiary can occupy the house rent-free. Enforce and defend claims. You have to take any reasonable steps to make sure that the trust is prevented or is defended against any challenges. And if somebody owes or had obligations to the trust, then we want to make sure that the trustee goes after any money that's owed, because ultimately that's to the benefit of the beneficiaries. Okay. Duty to collect assets. We just talked about that. Duty to inform and report. The trustee has an obligation to keep the beneficiaries reasonably informed about the administration of an estate, all right, as well as any material facts that they need to protect their interests. Most of the documents don't always say you have to do this accounting, right? They say, okay, give me an account. Well, most of the trusts don't require that, and most laws, most of the state statutes don't require it. The definition is reasonably informed. We always try to tell them, listen, do it at least once a year, right? Particularly if the successor has passed away, the initial trustee has passed away, the trust becomes its own entity and has to file a tax return annually. Send them the tax return. Send them the tax return. And so they'll have that's generally what has been accepted as keeping them reasonably informed. Now, if something comes up, the house burnt down for whatever, for something like that, then you probably need to tell the beneficiaries, yeah, we got a problem. Something went wrong there. That's not something you wait a year and say, oh yeah, I'll let you know on the tax returns that your parents' house burned down or your loved one's house burnt down. You probably want to get ahead of that. Okay, so now let's talk very quickly about the powers. The trustee may exercise all powers that are laid out in the trust, and even some broad general powers as well. It's very similar to the powers that a unmarried competent person that owns a property. All right. The trustee also has any powers appropriate to achieve the proper management and investment and distribution of the assets. Unlike the fiduciary duties described above, the trustee is obligated to perform and exercise the distribution of powers is discretionary. That power, you don't have to figure out exactly how to manage the property. I'm sorry, let me say that again. The trust often does not and cannot dictate how to manage certain investments or property, but it can tell you, give you guideline, and so you have the discretion, again, that common sense and within the boundaries of law, to be able to say, okay, I'm going to put this account in this brokerage house as opposed to that other brokerage house, right? Because you're familiar with that financial advisor and that brokerage house, so you can do it that way. I'm going to have this company manage the property for me, or this real estate agent to list it for me that way, so long as they're professional and they meet all the guidelines. Right? Okay, we're almost done. Compensation. This is one of the key. I'm sorry, no, we're talking about the distribution at this point. If you are the beneficiary of the estate, this is probably what matters most to you. One of the key responsibilities of trustees is to make appropriate distributions to the trust beneficiaries. The trustee must comply with the duty of impartiality in making distributions. You may have a favorite nephew or favorite niece, or one of them may be your godchild. It doesn't matter. You have to be impartial when you're making those distributions. And the timing has to be as consistent with each other. There are really three main types of distributions. There's the required distributions, there's discretionary distributions, and then final distributions. The required is obvious, the final is obvious, but the discretionary, when you're dealing with a trust, there are a couple of things that come with that. And it really is going to depend on what the document says and what the trust maker's wishes were. Some trusts authorize discretionary distributions without providing any guidelines or imposing any limitations on the trustees. Others contain specific guidelines to exercise the authority. For example, you can make distributions. You can make some distributions for the beneficiary's health, education, maintenance, support. We refer to it as the HEMS standard. That's the IRS standard, the health, education, maintenance, support. In this situation, the trustee must exercise substantial judgment in determining the needs of the beneficiary. And generally, health and education is kind of self-explanatory, but maintenance support has generally been defined as helping them to maintain the standard of living that they had become accustomed to prior to the grant maker's passing. Okay, so just because they may be now accustomed to eating filet mignon, when the trust maker was alive, if they were eating hamburgers, then the health maintenance standard is based on that standard of living. All right, so you only have to put money aside for them to have the hamburger and not the filet mignon. Okay. And final distribution rate, that's obvious when closing out the trust or doing any final end of trust distributions, you do it that way. Okay. All right. Now we'll talk about compensation. Most of the trust documents that we've done does allow the trustees to be compensated. Often in the absence of those clauses, however, whatever state or jurisdiction you're in says that you're entitled to it based under reasonable compensation based on the circumstances. That is such a gray area, right? But you really just need to look at the trust document to see what it says. Roughly, it comes out to about, in this area, 1 to 3% of the value of the estate annually is what the compensation, the reasonable compensation is. Now, of course, there may be other circumstances depending on how many beneficiaries and what else is going on, but generally, you're looking at 1 to 3% annually of the value of the estate. And that's also why sometimes they may say, you can close out this trust because it is no longer economically viable to do so. If it's only $50,000 and you're spending, the trustee's going like, I'm spending all this time for $50,000. It doesn't make sense. You can do the distributions at that point. All right. Liability. A trustee is not a guarantor of the money in the trust. So you are not responsible for the growth of the funds. All right. So if a loss occurs during the faithful performance of your duties, then you're not liable. If the money's earned in the brokerage account and the market collapses, you're not liable for that. If the house burns down through no reason of yours, through no account of yours, an arsonist got to it, then you are actually liable. And I'm sorry, you're not liable in that situation. Right? You did the security cameras and whatever happened, and somebody got in there, somebody did a criminal act. You're not liable there. So basically, you have to act reasonably based on the terms of the trust to avoid any liability from the beneficiaries for breach of trust. All right. Self-dealing. All right. Self-dealing is a place where discretion comes in, with the management of the assets, the accounts, and money that's in the trust. What does this mean? So at the same time that you're a fiduciary, you're also a beneficiary, and you see the house, and you figure, okay, the market value of the house is $500,000, but the appraised value, the assessed value is $350,000. And so what you do is you buy for $350,000. Well, that self-dealing is a problem, because what you have done is, and I'm going to use simple math again, you have 4 beneficiaries. If the house was at $500,000, each one of them entitled at $125,000 if it was sold at market value. By you only buying it for $350,000, now 5 people have to divide $350,000. 4 people have to divide $350,000. So they're taking a loss, but you got the benefit of the house. And so the only time that I really see self-dealing is if there's one beneficiary, and that person's successor trustee. Who are they harming? But often we never put self-dealing if there's multiple beneficiaries, right? So we in our documents, we kind of avoid that at all, right? So if there's one individual, then then self-dealing is fine. I should say one individual beneficiary, and that same person is a trustee, then that's absolutely fine. Successor trustee, that's absolutely fine. But if there's multiple, our documents don't allow the self-dealing to occur. Okay. All right. And how do you protect yourself to make sure you're not doing any self-dealing? Just follow what's in the trust. Make sure you're using common sense and you're being fair. That you're not doing anything that would cause question or that would cause you to question if somebody else did it. Now, there may be circumstances, as I said earlier, where the children, the siblings want you to have the house. Get their permission and get it in writing, right? Make sure you disclose everything, and this is called informed consent. Make sure everything is above board and everyone's aware of it. And lastly, you could go to the court and get approval of your action there, to make sure something happens along that line. So those are really the kind of the three ways that you want to do it. If the trust allows you to do self-dealing, good. If the other beneficiaries consent to it in writing with all the appropriate facts, you can't just give them full half the facts. All the facts need to be fully disclosed, and then, of course, going to the court. Well, that kind of concludes it at this point. I hope this has been somewhat helpful for those of you who are going to be serving in this role. Again, I know this doesn't cover everything. It's not intended to be the end all and be all, as I said in the beginning, but kind of give you a big overview a general overview of what's responsibilities of the fiduciaries in those different roles. Now, it's possible. I don't know if we have any questions there in the chat, but certainly if you have any questions or concerns regarding your estate specifically, we have the option here, because you participated in this webinar, we offer you a complimentary meeting to our clients and their fiduciaries to answer specific and personal questions and concerns. So if you just look on the screen there, you can kind of just scan that QR code. You can go right there and schedule a meeting with my office. Or if that's not, if that's not working for you, just call the office right there. You'll talk to Brianna or Angelique, and they'll make an appointment for you. Just tell them, well, we know who signed up for it, but you can just tell them that you got the number from the presentation and you want to have your fiduciary meeting, right? And also, if you have not done your own estate plan, then you might want to schedule a discovery link. Click on the discovery link with us. I don't know if that's on there. I don't see it, but we used to have it on there. But again, you can call our office, and we'll be happy to schedule a complimentary session with you to discuss your own estate plan. So I want to thank you for your time and your attention on this dreary Saturday morning. I apologize for the dynamics of what happened today, but it's interesting. It's a real life example of the benefits of having your estate plan done. My wife left for Singapore yesterday morning, and my mother-in-law, who lives with us, was at the senior center and collapsed. And so 911 came, paramedics took her to the hospital, and I show up, and they're like, oh, who are you? Fortunately, with her estate plan documents, I'm the backup to my wife. And so I've been able to, function in those roles, because while she was on the plane, couldn't communicate with her in any reasonable way. It's just a constant reminder of the benefit of having these plans in place, because you never really know what's going to happen. So, Angelique, Brianna, do we have any questions? Has any questions been posted?
No questions have been posted.
No question.
Okay. Well, then I think I did a great job, because no one has any questions. And so I think we'll conclude from here. And thank you for your time and your attention. And I will wrap this up now. Thank you.